So we do have some other sessions coming up. Today is again state and federal disability law. And on this Thursday, we're going to have an overview of what is a disability. September 13th, we're going to be hearing from the Division of Deaf, Blind, Hard of Hearing and get to know you sessions. And then the following week will be the same thing for the Bureau of Services for Blind Persons. Again, registration is required, and we will share these links in some emails after the fact, and most of you have received them if you've gotten the flyers from our office as well. So today we're going to start out by talking about federal disability law. First and foremost, the Rehab Act of 1973. We'll move into the Americans with Disabilities Act. And then finally, the Michigan Persons with Disabilities Civil Rights Act. And then we'll take a little bit of a closer look at what those laws really mean to us. And then we'll move into some Q&A. So starting off with the Rehabilitation Act. In 1973, the Rehabilitation Act was passed. And for our purposes, we deal with what's called Section 504. And it applies to any entity that receives federal dollars. It can be federal departments, contractors, and any program or services or activities that's funded with federal monies. This was the precursor to the ADA. For a long time, there weren't any federal protections for people with disabilities, and Section 504 requires that qualified individuals with disabilities cannot be excluded or denied benefits or subjected to any type of discrimination under any public-facing program, service, or activity by the federal government. Again, this was major legislation that affected many people, but it really didn't cover all aspects of public life. It was just those entities that receive federal funds. It also has a provision that says you cannot retaliate against someone who exercises their right under the law. Section 501, there's many portions to this law. Section 501 prohibits discrimination from federal entities in employment. 502 describes and carves out the duties of the U.S. Access Board, who are responsible for providing us guidance on how to implement these things. 503 applies to federal contractors and subcontractors in the employment setting. It says they also cannot discriminate in terms of employment or the work that they do. 505 lays out certain remedies available to people who feel that they've been subjected to discrimination. 508 covers those information technology accessible features of federal entities. And again, 504 is what applies to federal entities that receive monies from the government. So moving along, the next law that we talk about is the Americans with Disabilities Act. So as I said, the 504, the Rehabilitation Act was enacted, and it was great, but it didn't really cover all aspects of the world that we live in, including employment and businesses that are open to the public. So we see in 1990, the Americans with Disabilities Act was passed, and it contains Title I, II, and III, and some other provisions. But for our purposes, we really talk about those main three. So Title I says that employers with 15 or more employees, they cannot discriminate against people with disabilities and have to provide accommodations for those people in certain circumstances. Title II applies to state and local governments, just like Michigan Department of Civil Rights, Department of Health and Human Services, Corrections, Lottery, Treasury, and it says that any program, service, or activity that's open to the public, again, can't discriminate and have to provide accommodations to allow people to use those services. And then finally, Title III applies to places of public accommodation. And what that means are any business that's open to the public. So your grocery stores, retailers, doctor's office, lawyer's office, again, they have to provide equal access to and make all of their programs and goods usable to persons with disabilities. The ADA also says that, again, retaliation. So if someone's exercising their rights under the law, you cannot retaliate against them for doing so. Individuals with disabilities cannot be excluded from participation. They can't be denied benefits, goods, or services. They can't be denied access to programs, services, or activities. And they also cannot be subjected to overall discrimination, which could be in the form of comments or conduct as well. Sorry. So under Title II, we also have some things that apply to state and local governments, and first and foremost is reasonable modifications. So a modification is a change to any policy, practice, or procedure, the way things are normally done, in order to allow a person with a disability to benefit or use the program, service, or activity. That's one of the components for state and local governments. Another component is that you have to provide, or we have to provide, effective communication. That means communication that's clear and understandable to people with disabilities who have vision related or hearing related or cognition issues. And it has to be equally as clear and understandable to people with disabilities as those without. And then finally, it means program access. You have to, as a state or local entity, do what you have to do to make your services provided in the most integrated setting. And this also includes things that are web-based programs or services, not only just the architectural standards that we see getting into the door, getting up to the third floor, that type of thing, but also that IT component. And it may mean that you have to relocate programs or services in buildings that are inaccessible or older. So I just wanted to mention that 1990, the ADA was enacted, but there were some changes that came around in 2008. And that was because of the fact that several US Supreme Court cases narrowly defined what a disability was. And it really stepped away from the intent of the ADA, which is integration, self-sufficiency, and equal access. So the legislature made the amendments to make it not so difficult or a stringent definition of what a disability is. And it really focuses more on whether or not these covered entities, such as businesses that are open to the public, employers, and state and local government, are they discriminating against persons with disabilities? Under Title II, it requires that state and local governments with 50 or more employees, they're required to adopt and publish a manner or a mechanism for resolving grievances that arise under Title II. They have to also assign a person who's responsible for handling those matters, someone who's knowledgeable and familiar with disability law. And you can see here we have a screenshot of michigan.gov, and there's a disability resource page that lays out the ADA complaint procedure. And you can also click on these links to get to that complaint procedure. And also there is a link to all of the ADA coordinators. Each state department and the executive branch has at least one person assigned to handle reasonable accommodation requests and also complaints that may arise. So now that we've covered very briefly the federal disability law, we will talk about our state disability law. In Michigan, we have what's known as the Michigan Persons with Disabilities Civil Rights Act, and that was enacted in 1976. Article 3 applies again to state and local government departments, and it says that a person with a disability must be reasonably accommodated. We'll talk about what reasonable means a little bit later. It also prohibits retaliation against an individual who exercises their right under the act. So if someone files a complaint against a state or local entity under state civil rights law, it would be illegal for that department to then take some further discriminatory action against the person who did so. Not only do we have our state and federal laws, but we also have Michigan Executive Order 2004-31, which established the following. So it says that state of Michigan has to designate at least one state employee to be the state ADA coordinator. And they have to assist all of the executive branch department ADA coordinators in doing their job. And it lays out what the duties of the state and departmental ADA coordinators are. Basically, what I just said is to provide, assess reasonable accommodation requests that come into each department, and then also to handle grievances that come in. And our job is to assist with that as well. So what is the ADA compliance division? The division is made up of me, and as I said, I'm the interim coordinator, and I have a student assistant, Caitlin Johnson, who is behind the scenes today. And then we also have John Estel, who is our digital information accessibility person. And so what we do is that we make sure that the state of Michigan complies with all the laws that we just talked about. Every executive branch must comply with the ADA, the Persons with Disabilities Civil Rights Act, and Section 504 of the Rehab Act. We coordinate compliance with the executive branch. We support the role of the ADA coordinator. And that may mean providing training, technical resources, answering questions and guidance. We serve as the ADA liaison on behalf of the governor, and we oversee the grievance procedure. So as I showed you before, there is the screen where you can file a complaint against a state entity if you feel that you've not been accommodated, or you're not, you don't have access to the program or service. And we oversee that to make sure that the right person is addressing your complaint, that they're being made aware of it, and that some action is taken to assist you. State of Michigan Departmental ADA Coordinator. So again, each department under the executive branch has to designate at least one Title II person to handle those issues. They can assign, and they do have support staff to do that. If you click on the accessibility link in the footer of any michigan.gov website, it will take you to the grievance procedure link, as well as a list of persons who are assigned by department who can handle those complaints and help you. So next we'll take a closer look at disability. So what is a disability under the ADA? Excuse me. A disability is defined in one of three ways. It can either be a physical or mental impairment that substantially limits one or more major life activities, and this is what we would call an actual disability. Or if you don't meet that definition, but you have a record of being a person that has a physical or mental impairment that substantially limits one or more major life activities, there's protections for you as well. And finally, three, if you don't meet one or two, if you're a person who's regarded as having such. And there are different laws that have different definitions of disability. For example, Social Security will have one definition, workers' compensation. And when we talk about the definition of disability here, it's a legal definition under the Americans with Disabilities Act. So to delve into that a little bit deeper, what is a physical or mental impairment? So in order to be a person who has an actual disability, you have to have one or more physical or mental impairments, and they have to substantially limit a major life activity. A physical impairment can include things such as psychological disorders, cosmetic disfigurement, physiological disorders, cosmetic disfigurement, anatomical loss that affects your body system, such as neuropathy, respiratory, skin growth, heart conditions, those type of things. Or it could be under the category of a mental impairment, and those include those psychological disorders such as an intellectual disability, organic brain function, emotional mental illness, or specific learning disabilities. And then when we say substantially limits, we mean that your degree of functional limitation is less compared to the general population. It doesn't mean that you have to demonstrate that you cannot perform it at all. It just compared to the general population, you're limited. Not every limitation will rise to that level, but it's a case-by-case basis decision and factoring. And so there's no one-size-fits-all assessment. And then finally, it has to substantially limit one or more major life activities. And major life activities are things such as seeing, hearing, sleeping, breathing, but they also include, because of those 2008 amendments, which expanded a little bit more on that definition, major bodily functions as well. So major life activities, as I gave you a few examples, here's a list to the side. There's a chart that has caring for oneself, learning, breathing, eating, thinking, concentrating, working. These are non-exhaustive lists, but it's just to give you an idea of some of the things that could occur. And then, as I said, major bodily functions are included as well. And those are things where we think about those non-obvious disabilities. They're nonetheless substantially limiting, but you don't normally, and you may not see them. And those are things like things that happen with your immune system, normal cell growth, digestive issues, bowel, bladder, brain functions. And again, that is a non-exhaustive list as well. And we have these coverages again because of the 2008 amendment. Mitigating measures. So mitigating measures are things that normally assist you or reduce the effects of a disability. And again, prior to the 2008 amendment, the courts were not factoring. They were factoring these things in when they were determining whether a person met the qualifications of a disability. And so if you used a mobility device or a hearing device or some medication that assisted you, you may be excluded from the definition of disability, which doesn't make you any less of a person with limitations. And so those 2008 amendments came in and said, no, we're not going to look at that any longer when factoring in whether you meet those definitions. The only exception is if you wear ordinary contacts or glasses. So you can still have your mitigating measures and still be considered a person with a disability now. Another thing that changed in those 2008 amendments were coverage for episodic impairments. If a condition prior to that was episodic, meaning it only occurred occasionally or infrequently or at irregular intervals, it wasn't covered as a disability. But now, if a condition substantially limits a major life activity when it's active, it will be considered to be covered all the time as a protection. So that was our actual disability: substantial limitation, major life activities. Now we move on to another way that you can be covered if you have a record of an impairment. And that protects individuals, again, who have a history of a disability, whether or not they're currently substantially limited in a major life activity. And these, some examples, again, non-exhaustive, includes a history of cancer or heart disease or other debilitating illnesses that are either cured or controlled or in remission. And then finally, if someone was erroneously classified at some time in their life as having an intellectual or learning disability. So you're not currently experiencing the disability, but you have a history of that, you are protected under the law. We'll talk a little bit about alcoholism and drug addiction. Alcoholism as a disability is covered under record of and also under the physical or mental impairment, alcohol dependency. It's illegal drug use is not protected as a disability under the ADA unless the individual is no longer using. And recovery, there's no bright line test, but it's basically when a person can show that they're not engaging in the illegal use of drugs. And illegal can be drugs that are illicit or prescribed but not being used in the proper manner or the manner that they're prescribed. And it has to be a justifiable amount of time to show a belief that a person, their recovery is real, there's no ongoing problems, that they've ceased engaging in the use of drugs, and they're either participating in a supervisory rehabilitation program or they've completed a rehabilitation program. So there is a little bit of difference between alcoholism as alcohol dependencies, the current protections, and then you have to no longer be using if it's a drug addiction. And then finally, we talk about our final way you could be protected under a disability component is if you're regarded or perceived as having an impairment. These are individuals who have an impairment that's not substantially limiting, but they're perceived as having such. So you may have something, but it doesn't substantially limit you from doing any major life activities or any bodily functions, but other people see that or know of that and perceive you as such. Or it can be people whose impairments are only substantially limiting because of the attitudes toward others. Could be a myth, stereotype, misconception about what that disability or impairment is. And then finally, individuals that have no impairment at all, there's nothing mental or physical, whether it's a bodily function or a life activity, but due to the subjective perception, they're being regarded as having an impairment. And here is like a birthmark or a scar. This prong also provides protection against, again, as I said, stereotypes, assumptions about what people think it is to be a disability. Because we know in our country, there's been a long and really terrible history of discriminating against people with disabilities and making assumptions about what it means to be a person with a disability. Next, we'll talk about a closer look at accommodations. So again, when we use the word accommodation or modification, though they're used interchangeably, under Title II, the word modification is used, but in Title I, it's accommodation. They mean pretty much the same thing. It's just a change to the way things are normally done to allow a person with a disability to participate or have equal access. Many routine policies and procedures have been implemented in our world without regard to how they affect persons with disabilities. And, our world is built not around an inclusive lens. So the law says, we have to make those changes to allow people with disabilities to participate. And here are some examples. So if there's a no pets policy somewhere at a park or apartment complex or something like that, that's fine, as long as they make exceptions for service animals. Allowing a person to bring a support person to complete an application. We're getting ready to, gear up into voting season again, and that means allowing someone to have assistance in the polls. Allowing the use of a mobility device on a walking path or a hunting path or a hunting trail. And allowing food consumption at a public pool for someone who has to eat small meals in order to control, their medical condition. It's important to note that the ADA requires equal opportunity, but not necessarily an equal result. So accommodations overview. So when someone requests an accommodation, they don't have to use any specific words. They don't have to come to you and say, I require a reasonable modification to assist me with my disability. But they have to specify that the request, what they need, is due to a disability, unless it's obvious. There's no time frame as well. So as a member of the public, you can make a request at any time. If you're trying to access a program or service of the state of Michigan, and you need some assistance in doing so, you can request that at any time. Pardon me. It doesn't necessarily mean that your accommodation will be granted if the time frame isn't tenable, but you can always make that request, and a state or local government has to do its best to try to accommodate you. And it doesn't have to be in writing, so requests can be verbal, and they can also be made on behalf of a person with a disability if assistance is required. Continuing on that path, requests have to be reasonable. So what that means is it cannot, what you're asking for cannot fundamentally alter a program, service, or activity. So if you're asking for something that's not offered to anyone at all, if you're asking for something that will change the very nature of the program, that may not be considered reasonable. If it will impose an undue hardship, either economically or administratively, it's very hard burden to meet for a state to say, oh, what the person is asking for is just too expensive, because generally it's not. And we look at the state's budget as in total, not just the particular department, to see if for some reason it were to be considered an undue hardship, you still have to find other ways to accommodate that person, alternative means to do so. And then finally, you don't have to, a public entity does not have to provide things that may jeopardize the safety of other people or yourself. But accommodations do have to be effective. So if someone is asking for American Sign Language interpreter, but you provide CART services or some other way to communicate, such as writing notes, if that person isn't proficient in those other avenues, then that would not be effective, and it wouldn't be reasonable to provide an alternative accommodation. And then accommodations have to be granted on a case-by-case basis, or tailored on a case-by-case basis. So if one person asks for something and that works for them, that's great. But if another person comes in with a similar type of disability and you just want to apply that same accommodation, that may not work for another person. So you have to make sure that you are tailoring and catering the needs of the person to make sure that they're able to benefit fully from the program, service, or activity. And an interactive process. So what that is, it's a tool that we use to fully make sure that we're fully addressing and vetting accommodation requests when they come in. There is it's not set in stone, but generally this is what we like to do. It's 6 points, is that a request will come in. You recognize that a request comes in from someone with a disability or on their behalf. And as a public entity or an employer or a business doing a public offering business, they have to acknowledge that the request came in. So you're not hanging out there wondering if your request was received. That gives the time for the entity, such as the department or business, to gather information and ask clarifying questions if necessary. This doesn't mean that we can ask for deep dive information about a medical history or your background. It's just if a disability is not obvious, or if it's not obvious what you're asking for or clear how the connection will be made between the disability and the need, we can just get a little bit more clarification. And next, we determine if an accommodation exists and if it's reasonable and will be effective. And then finally, we implement that. And implementing that means letting the requester know that your accommodation will be granted, or here's an alternative accommodation. And we have the responsibility to maintain any medical confidentiality and not talk about your medical history or request with other people. And it's basically on a need-to-know basis. And then finally, evaluation or reevaluation. So if an accommodation is working, that's great. But if things change for the person as far as their condition or technology or accommodations that are offered, then we may have to reevaluate to see whether that's still effective. So again, this is just an overview. Requests can be initiated by the person with a disability. Both parties have to engage in the process and act in good faith. If one person or one side ceases or stops that communication, that may be an issue with compliance. So if a member of the public asks for an accommodation to participate in something that the Department of Human Services, Health and Human Services was doing, and the department asked for some clarifying information, and then the requester didn't provide it in a reasonable time, that may be where it breaks down. And either the department would have to let them know that we need this and we can't proceed, or try their best to accommodate. But it's really important that good faith efforts are made by both parties. Okay, so we're moving on to a closer look at effective communication. Effective communication, I mentioned very briefly, it's communication with people who have disabilities, and it must be as effective as communication for people without disabilities. This is the only way to allow for equal opportunity for the person to participate and benefit from. It applies to the presentation and exchange of material. So it's not just what I'm saying to the person, but what they're saying back to me. It has to be communicated and understood in both ways. And this may require providing auxiliary aids and services to that person. Auxiliary aids and services are methods to make written, spoken, or visually presented information accessible to people with disabilities. Title II entities such as state and local governments cannot charge any money for providing auxiliary aids and services, or barrier removal, or alternatives to barrier removal, or other modifications. So you can see here today we have two interpreters, Bethany and Toy, and we also are providing CART services, which is a visual representation of the words that are being spoken. We're providing those because we are a state entity and we have an obligation to make the work that we do accessible, and we cannot charge for that. Auxiliary aids and services, just a little bit more on that. It's a resource needed to provide the effective communication, and here are some examples. Again, it's a non-exhaustive list. Qualified interpreters, that means that you cannot require a person to have their friends or family or someone that they know sign for them. Assisted listening devices, which amplify sound, audible or electronic formats of documents or programs, captioning, braille, large print, note takers, sometimes providing oral instructions, qualified readers, and so on. Always consider the nature and length of the communication and the complexity. So that means there are higher burdens when there's something involving the legal system or medical. You have to have the proper people who are certified and vetted to be providing those types of services. So there are different avenues for that. And we, as I said earlier, on September 13th, you will, if you attend the session, you'll get to know the Division of Deaf, Blind, Hard of Hearing, and their division director, Annie Uraski. She'll be talking in more depth about some of these things as well. Personal use items. So personal use items are things like hearing aids, mobility devices, prosthetic limbs, and those are things that are not covered. So a Title II entity or Title III, Title I, any business that's open to the public or your employer, they don't have to provide or purchase these types of items for people because they're very tailored to the person with the disability. They're highly personalized. program access. So when we think of program access, we think of integration. And that is one of the fundamental tenets of the ADA. So public entities, although they can offer specialized programs for persons with disabilities, it can't be the only way that the person with a disability can participate. So for example, you see, pardon me, on the screen, we have a museum tour schedule. So at 9 to 11 is a guided tour that's open to everyone. And then noon to 1 is a local artist lunch. And then 2 to 4 is another guided tour where ASL will be provided. So a person who requires ASL is welcome, and they can attend the 2 to 4 session, but they have to be allowed to attend the one that's open to the general public from 9 to 11 as well. So a closer look at denials, and sometimes these are called defenses, but why an entity can deny a reasonable accommodation. So the ADA requires state and local entities to provide reasonable accommodations, but it doesn't require that every request under every circumstance automatically be granted. Every request should be assessed on a case-by-case basis, and there's no set definition or metric to determine what's reasonable. And this is also the case under Section 504 and the state law as well. There are requirements to accommodate folks as well. So covered entities should consider whether providing these requested accommodations would do one of these three things. So if what someone is asking you would fundamentally alter the program or service, you don't have to provide that, but you still have to engage in the interactive process to find a way to accommodate that person that meets their needs. You don't have to provide an accommodation or modification, or we don't have to, where one would impose an undue financial or administrative hardship. As I said before, this component or this defense is really difficult to meet for a state or local government because there's a lot of money, right? Even though they're always saying the state doesn't have a lot of money in terms of accommodations, there's money there. And we are stewards of public funds. And so we have a high obligation to make sure that what we are doing is accessible to people. So it's very rarely a defense that is legitimate under state or local government. And then finally, the state or local government or a business that's open to the public or your employer, they don't have to compromise safety. So if what you're asking for may result in, harms to yourself or others, then they don't have to provide that. But again, anytime there's a denial, there has to be a re-engagement of the interactive process to try to find a way to make that happen. Direct threat. Okay, so a direct threat, again, is a significant risk to the health or safety of others that can't be eliminated or reduced to an acceptable level by modifying some policy, practice, or procedure, or by providing auxiliary aids and services. A person with a disability in some circumstances could be excluded if they pose a direct threat to the health and safety of others. The Department of Justice provides guidance on these on the ADA, and they have not explicitly stated that this means harm to self, but there is some case law under Title I that says harm to self may be a valid reason for denying accommodation. But again, denying accommodation only means you have to go back to the drawing board to try to find a way to make it work. And everything is based on a case-by-case situation. When you do an individualized assessment to see if what's being requested may result in a direct threat, you can't just speculate or suppose. You have to assess what the nature, duration, and severity of the risk is, the probability or likelihood that someone will actually be hurt, and whether there's something that you can do to mitigate that risk. So we are going to move on to the Q&A session. I know that's a lot in a little bit of time, but it's really just to give you an overview. And when we go into our other sessions starting on Thursday, we're going to talk more in depth about disability. What is a disability? Getting to know your deaf, blind, hard of hearing Bureau of Services for Blind Persons. We have other trainings coming up in October and November that are going to flesh these things out a little bit more. So just a reminder about Zoom's Q&A feature. Anonymous questions are allowed. Again, we can't tolerate or have inappropriate language or conduct, but we will answer questions that don't constitute legal advice or comment on a pending case or litigation. And again, if you need the technical assistance, you can contact Zoom directly. So I'm going to go into the Q&A and look for some questions and try to answer them, okay? Okay, someone asked, will the recording be shared with attendees through email? Yep, we are recording this session today and it will be shared. Okay, so someone asked a question about housing. It says, what if a handicap apartment is not up to ADA codes? Who do we call? Yeah, so today we're really focusing on the overview, but if you have an issue with housing as it relates to disability, you can contact our department, the Michigan Department of Civil Rights, and you can speak with someone in the intake unit and they can transfer you to someone who works in our housing, on our housing teams, and they can talk to you about accessibility and your rights under the housing, under housing. Okay, is there, those are the only two questions there, so I can keep it open for a little bit if anybody has any additional questions they want to ask. Oh, okay, here we go. Can you talk more about the requirement of secondary education to supply interpreters, both private and public schools? Well, what I can talk to you about is the ADA, right? And so the ADA requires any state or local government entity to provide reasonable modifications to allow persons with disabilities to have program access and access to programs and services. So if that means that there is a student who requires that, going back, and I can, go back to some of those slides that talk about the interactive process, which I'll do really quickly. This is what you do. You follow this. This is kind of like the template that we follow, is that you receive the request, acknowledge the request, gather information if necessary, and then if someone, make sure what they're asking for. Do they need American Sign Language? Do they need sign language in Spanish or another language? Do they need CART services or Braille? Whatever it is, make sure that you understand correctly what they're asking for and determine whether you can provide that, and then you implement that. So, I mean, I can speak in generalities about how how those types of accommodation requests are processed and come in. Okay, so can you address how the ADA and state law applies to traffic stops by law enforcement when the driver or a passenger has a disability? So again, ADA, and this is like the overview, right? It applies to all state and local government entities. So Michigan State Police has a requirement, just like we do, Department of Civil Rights or Treasury or Lottery, to not discriminate against persons with disabilities and to provide reasonable modifications of program services and activities. So it depends on what that person requires. If it's a person who requires American Sign Language, they have to, again, go back to this interactive process, right? And I can't speak to the policies that the Michigan State Police or county sheriffs have in place for how they vet their accommodation process, but this is basically the format and outline that that should be followed, right? If someone requests an interpreter or something like that. So all of those things that we just talked about, Title II of the ADA applies to every executive branch in the state of Michigan and local governments as well. And also there is, as we said earlier, Section 504. So if an entity receives federal dollars, they have that obligation as well. Same thing. You have to provide accommodations. You can't discriminate. And then under the Michigan Persons with Disabilities Civil Rights Act, same thing. And then state policy as well. Okay, there's another question. What can an individual do if an entity tells them different accommodations should be sufficient, but the individual does not find it accessible? Right, that's what we talked about earlier. So if you request a very specific accommodation and I'll just say provider or entity says, no, what we'll give you something else. They have a duty to make sure that what they're giving you is effective. So in other words, if you request something, you don't always have the right to have the accommodation that you prefer, but you have the right to have one that's effective. So they would have the burden to show that it's effective, right? If they're offering you an alternative accommodation from what you're asking for, and you're saying it's not effective, they have to show that it's not effective. And if you don't think it's effective, that's, and it, again, this is if it's a Title II entity. So if it's a state or local government entity, for our purposes of the executive branch departments, if you're trying to access a program or service through the state of Michigan and you're not able to, because they haven't provided you with an effective accommodation, you can file a complaint with the Michigan Department of Civil Rights, or at least talk to somebody there to see if you can file a complaint. You can also do that Title II grievance procedure that we talked about earlier, and I'll go back, it's quite a ways, but right here. So here you go to michigan.gov /ADA, and it will take you to that link, the disability resources link, and you can file a complaint if you feel that you've not been adequately accommodated. Okay, here's another one. Can you give some examples what is not covered under the ADA or 504? Who could refuse accessibility? Well, the example, okay, so for the ADA, again, there's Title I covers employers with 15 or more employees. Title II covers state or local entities that have 50 or more. And then Title III is any business that's open to the public. There are some exemptions for religious entities. They're not covered by the ADA. So those are what's covered. And then who can refuse accessibility? Going back to what we talked about, the reasons that, let's just say you are covered, right? Let's say the entity is covered. We've gotten past that. There's no exemption. They have to provide accommodations unless they can, the defenses that come in. There we go. The reasons for denial. The reasons for denial, there's three, right? If it fundamentally alters the program, service, or activity, they can deny that requested accommodation, but they have to try to find something that will work. They can deny an accommodation if it imposes an undue financial or administrative burden. And we said that that's really hard to do for a state or local government. And then if what is being asked is something that's going to compromise the safety of other people or the requester, then they can deny that. So those are the reasons that an entity can deny a reasonable accommodation. There's very little exemptions. What if we don't hear back from a complaint? If you're talking about a complaint through the Michigan Department of Civil Rights, you could, everything should really, you should try to, as much as possible, follow up things in writing. If it's through the Title II ADA complaint process that we administer, you can reach out to us directly. If it's for a complaint that you don't hear back from, we have our website information, and I'll go to that. So you can see the information where you can email us right here. So the email for the Department of Civil Rights is MDCR -info@michigan.gov. So if you don't hear back from a complaint or you need to speak with somebody, you can email there. If it has to do with the Title II grievance procedure process and you're not hearing back from someone, the website is michigan.gov ADA, and that's an email address. It'll take you to our, oh, sorry. The email is ADA compliance issues at michigan.gov. Caitlin and I both monitor those emails on an hourly basis. So generally nothing slips by, but sometimes it does. And we, you know, if you aren't hearing back regarding your complaint, you can email us and we'll try to get back with you within 24 hours. Okay, there's another question. Are there legal resources beyond the MDCR complaint process available to those who are being denied access? So if we're talking about access under the Americans with Disabilities Act, you can always contact the the Department of Justice, the U.S. Department of Justice. They can take, or at least vet complaints under the ADA. If you have complaints through an employer, against an employer, the EEOC is another avenue to explore. And if the Department of Civil Rights isn't the avenue you want to go, but both laws allow for people to file civil lawsuits as well, if that's the route that you want to go to as well. I'll just wait a minute to see if there's any other questions. I think I answered them all. I'm trying to look back and see. Okay, I'll just wait a minute. If anybody has any other questions they want answered. I know we set aside an hour and a half for this, but certainly don't have to take up your time if you don't have any more questions. I'll just remind you again, we do have another training session coming up on Thursday, and that is more in depth of what is a disability. We'll take you through that a little bit more. And then there will be an opportunity to ask questions as well. On the 13th, we have our get to know you session, starting with the Division of Deaf, Blind, Hard of Hearing, and you can ask questions there as well. And then the following week will be a same get to know you with the Bureau of Services for Blind Persons, and questions will be welcome there as well too. Okay, I don't see any other questions, but if you think of something later, you can certainly email us at the ADA compliance issues at michigan.gov website, and we'd be happy to try to answer for you. Thank you all very much for attending our session today. It was short and sweet. As I said, it will be recorded and sent. It is being recorded and sent out to everyone. And we did have some issues at the beginning with captionings, but they can be viewed, and Caitlin did put that in the chat. Just want to make sure everybody's aware of that. All right, if barring any other questions, thank you very much for attending, and we will hopefully see you on Thursday.